Does the Second Amendment protect an individual's right to keep and bear a double-barreled, sawed-off shotgun? To find out, you have to read U.S. versus Miller, but it's 20 pages. Don't have time for that? I've got you covered. This is TLDR, Too Long Didn't Read, Landmark Cases. This is a channel where I analyze landmark cases in a variety of controversial and important areas of the law. This is one about the Second Amendment and the right to keep and bear arms. This is the episode on the case of U.S. versus Miller. This can be found at 307 U.S. 174 from 1939. This was published by the United States Supreme Court on May 15th of 1939. And the issue in this case is whether possession of a sawed-off double-barrel shotgun is protected by the Second Amendment. The law you have to understand to appreciate what's going on here is there's two different areas. First is the Second Amendment itself, which is the Second Amendment to the Constitution, and it states, I'm going to give you the quote, "A well-regulated militia being necessary to the security of a free state, the right of the people to keep and bear arms shall not be infringed." And the other statute that arguably is in conflict, according to the defendants in this case, is the National Firearms Act, which makes it illegal to transport across state lines an unregistered firearm. The facts in this case are essentially there's two different defendants, and they're part of a gang here, Frank Layton and Jack Miller, and they transport from Oklahoma to Arkansas a double-barreled 12-gauge shotgun that's sawed off, so it's less than 18 inches. So they have a sawed-off double-barrel shotgun transporting from Oklahoma to Arkansas, and it's not registered. So it violates the National Firearms Act. They're prosecuted by Arkansas federal court, and they make a motion to dismiss, saying, hey, we're being prosecuted for this unconstitutional offense. The crime itself is not constitutional because I have a right to keep and bear arms under the Second Amendment. The district court buys that argument, agrees with it, and it goes to the Court of Appeals. And here we have a unanimous decision by the United States Supreme Court, written by Judge McReynolds. And what the unanimous court says is that this is not a violation. This is not a violation of the Second Amendment. The statute does not violate the Constitution because the language of the Second Amendment is specifically tied to a militia. And essentially what the court says is there's no evidence before us that a sawed-off shotgun is used by any militia. And since it's not a militia tool, it's not used for the common defense, it's not protected by the Second Amendment, which is there to protect militias. And they go through a history lesson about the early United States where there's troops, standing armies, and militia. And they say that the early United States disfavored standing armies because that's what the British had. And instead, they favored militias, which are civilians most of the time, and soldiers every once in a while, like National Guard. And they go through the fact that Congress, specifically one of the powers in the Constitution that Congress has, is to call forth the militia. And as a result, the militia has to have weapons to be able to protect themselves and the country to either repel invasions or put down insurrections. So the Second Amendment is tied, according to the unanimous decision here, to the congressional constitutional power to call forth the militia. So if they're going to call forth the militia has to have weapons and be utilized and be trained in those weapons, and that's what the Second Amendment's about. And the court goes through the fact that multiple of the colonies, Massachusetts, New York, Virginia, all had requirements that all able-bodied men, very young, boys even, 16 to around 40 or 45 or 50, were required to be part of the militia and had to, at their own expense, have their own weapons, have muskets, bayonets, cartridges, cartridge boxes, powder, all the weapons that they would need as a militia. And the Second Amendment provided that they were not deprived of those things. And the important quote from this decision is, in the absence of any evidence tending to show that possession or use of a shotgun having a barrel less than 18 inches in length has some reasonable relationship to the preservation or efficiency of a well-regulated militia, we cannot say that the Second Amendment guarantees the right to keep and bear such an instrument. So if it's not related to what a militia uses, then it's not protected by the Second Amendment. And that's the case of U.S. versus Miller. Have a good day. If you like what you just saw and want to see more just like it, please hit like or subscribe to let me know.